Again, good afternoon and welcome to today's webinar. Again, my name is Michelle Peterson and I'm the Training Manager for the Empire Justice Center. I do need to note that today's webinar is made possible by the New York State Attorney General Homeownership Protection Program and in collaboration with Legal Services NYC. Before we get started, just a couple of notes on how you can interact with us. Everyone has entered the webinar in a listen-only mode. If you have any questions on the material being presented during the webinar, enter your questions in the questions pane, which is located on your control panel. We'll be addressing questions both during and at the end of today's presentation. For the materials for today's webinar, they can be downloaded by going to the handouts pane, which is on your control panel. Here you're going to find a copy of today's PowerPoint, 2 additional handouts, and the attorney affirmation form for anyone that's seeking CLE credit. We're going to be providing 1 credit in professional practice, and to receive your certificate, you'll need to note the verification code on your attorney affirmation form when we announce, and send your completed certificate to my attention. For any non-attorneys out there who want a certificate of attendance, we can also provide that. So you'll have to send me an email directly requesting your certificate. I'll put my email address in the chat box. And at the end of the webinar, you're going to be asked to complete the webinar evaluation, so take a moment to complete that as well. And with all of that housekeeping out of the way, I'm going to turn it over to Jay Inwald, who is our moderator for today. Jay?
Thanks, Michelle. Hi, I'm Jay Inwald from Legal Services NYC. I'd like to thank the Empire Justice Center for co-presenting this with us and for making it possible to broadcast it as a webinar. Mainly, I wanted to introduce our 2 trainers, and after that, you won't be really hearing anything from me, although you may hear from Becky Keiko, who will help moderate the questions as they come in. I wanted to introduce, first of all, we have Amy Hammersmith. She's the coordinating attorney of the Fair Housing Project at Queens Legal Services. So I think it's fair to say that she lives and breathes the issues of housing discrimination, in particular in Queens, and I think she's uniquely qualified to help train us on using the various administrative tools that we have at disposal. And I wanted to introduce Rachel Jabal, who's from Brooklyn Legal Services. She's also uniquely qualified to train on this subject today. First of all, she has 2 federal jury trials under her belt in which significant discrimination issues were litigated, which some of you may have heard about if you're on the various listservs. So I'm not going to belabor all of that, but I want to thank them both for taking the time to prepare this and to get us thinking about using the administrative tools that we have at our disposal. We can't all spend 7 years litigating a federal case, but using the administrative proceedings that are available is a lot more doable, and I think it's something that, as we enter this changing environment, we should all be thinking about. That having been said, this session was conceived in a different world before the election, so there are some questions about what HUD is going to look like, but we'll leave that for another day and nonetheless acquaint ourselves with what's on offer there, at least on the books. So with that, I'm going to turn things over. I think Amy is going to get us started. So take it away, Amy.
Thanks, Jay, and thank you, everyone, for making this possible. So we're going to talk today about fair lending and fair housing, bringing administrative discrimination claims. I think everybody who's on the call probably has a sense of why it's important to bring claims about discrimination generally. I think we all recognize that they often tend to hover below the surface of things that appear in other guises. It's important to bring it to the attention of administrative agencies who are charged with counting these things so that they have a sense that discrimination is still out there and what types of discrimination are happening. It also assists our clients because in the process of litigating discrimination claims or bringing administrative actions, we can gain leverage to pursue successfully other remedies that folks need whether it's in landlord and tenant court, whether it has to do with access to services, modifications to mortgages, etc. So just to give you, I think most of you have been litigating for a while and have a sense of what discrimination might look like, but I think we're just going to quickly go over, what is discrimination, what ways does it come up. So in the housing context, discrimination, in its most blatant form will appear as physical and verbal threats or harassment that are directly related to a protected characteristic. Things like, I don't like the way your people's food smells, or we don't want, Latinos in this building. That still happens, though less often, because people are getting smarter about the fact that they have to hide or not be so obvious about their biases. Differential treatment is another way that discrimination appears. The slide gives the example of performing repairs in a building for younger tenants, but never getting around to repairs for the elder tenants, or putting elevators out of service for irrationally long times, unreasonably long periods of time, so that elderly or disabled tenants have trouble getting to their apartments and in some cases give up and move out. Obviously, steering applicants for housing to build. So a large landlord may have several buildings, and Bengali tenants may be steered to one building. Latino tenants may be steered to another building. So that's a form of discrimination, and that's a form that sometimes it requires testing or deeper investigation to be obvious. Repeated and baseless litigation in various different forums, and uneven enforcement of building rules. Who can use the pool if there is one, or who's allowed to leave their carts in the hallway, who's told, no, you can't keep that here, we're going to bring a holdover against you for violating your lease because you have a granny cart sitting in the hallway, that sort of thing.
And also in the lending context, there's quite a bit of discrimination, and some things we see, we think about them as predatory practices and don't always think about the discriminatory elements to them, but a couple are listed here on the slide. So reverse redlining, which is targeting predatory products or predatory characteristics of a product towards particular neighborhoods because of their racial composition. So predatory FHA lending only in certain neighborhoods, high fees, fee packing, very high interest rates, all those things, if they're targeted, they are discrimination. One-stop shops, which we saw quite a bit some time ago, deed thefts, which we see quite a bit now, if loan mod scammers, so people going out and flyering that they can help people get a modification, if those things are targeted on the basis of race or base of another characteristic that's protected by the anti-discrimination statutes, those discrimination. And also servicing practices may well be discriminatory if they're targeted to a particular community based on language access or things like that, or even if it could be disparate impact depending on the pool of loans that is being serviced and the racial characteristics of those loans.
So, for the first several years of my own practice, I did not even think about administrative complaints as an option. And I think a lot of us tend to think about court, but there are reasons why administrative forums can be a good choice. It is free to file in administrative forums, so if you are concerned, often we represent people who can get waivers of the court fees, but if you're representing clients who do not have that possibility, or you are helping someone file pro se papers, this is a free process. The burden tends to be on the agency to do a lot of the initial upfront investigation, and so it can be a way to conserve resources. The papers that are filed initially can be as basic or as complex as you want. They are often, mine tend to look more like court papers, but they can be fairly simple and quick, especially if you need to avoid a statute of limitations problem.
And similar themes in the discovery area, as Amy said, the burden is on the administrative agency to perform discovery. So it can be quite a bit less burdensome than being in court. They will lead that charge for you. As we will discuss later in the presentation, there are ways that you can make that more meaningful to you. But that is certainly a way it's less burdensome. Also, there is, just like in court, there will be conferences to try to settle. The agencies are all required to try to settle or conciliate claims, and so there is an opportunity to do that in the context of the administrative action.
One of the other pieces, and this sort of cuts sometimes in the direction of bringing a case, litigating a case in court, the damages are often not as high in administrative forums. They're sometimes capped. You always get actual damages. Punitive damages are only available in some forums. The state, for example, the city and the federal forums do not actually have punitive damages as a possibility. Civil penalties can be awarded, and they all have the power to issue some level of injunctive relief. What that actually looks like is, in many cases, untested, so we can't give you a definite answer about can they order X or Y, but they do have the power to order injunctive and equitable relief and attorney's fees. Other things to think about, sometimes you have a client who might not present, you're sort of talking to them and either they're incredibly nervous or you feel like they may not present particularly well in one forum. The informality of an administrative forum may make them more comfortable. They're sitting down at a table with someone who's often fairly sympathetic to them, at the initial stages talking about what happened to them. And that's a way to ease a very anxious or nervous client into feeling more comfortable, particularly because they may perceive that they're taking a risk in filing an affirmative case against their landlord or against a broker. They may fear retaliation.
And then there's a few slides here that have some other, a little more detail about some of the things that we've discussed, and you'll note some additional thoughts. You can think about the complexity of your claim. There are some kinds of claims that may not really get as much attention in the administrative forum, like disparate impact claims. And also, you should think about your statute of limitations. It's shorter in the administrative forum, but by filing, you do toll that statute of limitations. So it is also a way if you think you're at the end of your deadline and you just want to have a way to put those claims out there, and you can then later withdraw that complaint or make an opt to bring that after the initial administrative process is over, bring it in court. You have that opportunity to do so.
Yeah, and one of the, I think, underutilized possibilities of administrative complaints is that if you think a process or a form of discrimination might be widespread, I think that we should think more strategically among ourselves about bringing cases and really pushing the agencies, because they have the power to do these system-wide investigations, and they're, when they take these on, it is the state or the city saying to the person, the entity you're complaining about, you are discriminating. I think there's real power in that. It does take a little pushing, but I've seen it work at least in one case. In the City Human Rights Commission, they are doing a system-wide investigation of a particular landlord for multiple uses, and it's really making a difference. So there are some reasons, obviously you may not want to use the administrative forum and file an administrative complaint. The process is not necessarily fast. So, federal cases take a long time, but so do administrative complaints. And it's not always clear what is happening during that time. Litigation, as we said before, can offer the potential for higher damages and in some cases offer punitive damages. Complex claims might be better suited to federal or state courts, and the statute of limitations for administrative complaints is 1 year from the last instance of discrimination. Most of the statute of limitations for lawsuits are longer. Most of them are 3 years. I think some are as high as 5, and some are as short as 2.
And then we're going to talk about choosing your forum also. There's federal and there's state, and for those who are in New York City, there is the City Human Rights Commission. And there are things to think about in terms of where you're going to choose to bring your administrative complaint. First of all, we discussed statute of limitations. For all of those fora, it is 1 year. However, there are tolling theories, and those are differ in the state and the federal law. And also, there are definitely different treatment of those statute of limitations between the administrative forum and the courts. Now, there shouldn't necessarily, and that may be something that you're really going to spend quite a bit of time talking with your investigator about, but for example, there's no discovery rule in the state law. So you can think about, if you're going to need to have tolling, make sure that you're thinking about where you'd want that and how it's going to be treated. Investigator receptivity, you'll get a sense as you're bringing these claims about where, how you can talk to your investigators and how sophisticated they'll be about various kinds of claims, but it's definitely something to think about. For example, at HUD, they may have seen a certain kind of discrimination or have dealt with certain kind of discrimination that the state authorities haven't seen or dealt with in the past. Damages and fines do differ a little bit. We're going to talk about those a little later in the presentation. The covered characteristics, it's really important, differ between the federal law and the state law and the city law. We're not going to talk a whole lot about the city law today because we have people from around the state, but just briefly, we do have some slides about who's covered by what laws. The Fair Housing Act, you can see here, race, color, religion, sex, family status, national origin, and disability.
And just in case your people are sort of not as familiar and wondering, family status refers to the presence of minor children in the household, so children under the age of 18. It's generally been expanded to cover pregnant women or people who are looking to adopt children. And color is separate from race, so they are not the same category.
And there has been some expansion in recent years about sex to include gender as well. Under the state human rights law, we have those categories and also more, including sexual orientation and military status.
Yep. And there's, some of you might be familiar, there is legislation which would include gender expression or gender identity as part of this. So far that hasn't been explicitly included.
And then finally, the human rights law, the city human rights law, excuse me, includes age, alien-age citizenship, gender identity, partnership status, pregnancy, and sexual orientation, and source of income, which is not listed here.
Yes, actually, some of these, sorry about this, there are actually a couple that were part of this and seem to have fallen off the slide. So source of income, and that's also included in the state human rights law, but source of income, meaning if the rent is paid through a subsidy like Section 8 or FEPS, or, if someone is discriminating based on disability income, saying, we don't want to take that, we don't want to take welfare, etc. A recent addition in July of this past year, domestic victim being the victim of domestic violence has also been added to the New York City human rights law as a category of people who are protected.
And then finally, I'm not going to flip back to the slide because it's a couple of slides back, but there are some differences in terms of the rules of evidence in the various forums. So in the federal forum, the federal rules of evidence do apply, and there's a little bit more rigor to that process. Not to say that that necessarily will be to your favor or against your favor, but that is something to consider. And in discovery, we're going to talk about a little bit later, there are some more formalities and some things that you can accomplish in HUD and the federal forum that you can't do elsewhere. HUD, as a matter of course, will refer your complaint to the State Division of Human Rights. That is something that's part of the law, that they can do that, and then they do as a matter of course. So if you do want HUD to consider your complaint and keep it and pursue it, you may have to do some discussion with HUD itself, and you can certainly email Amy or myself if you want to talk about how you might do that. So maybe this is a good time to take, if there's any questions.
Yeah, that seems like a good.
So there's one question that's been raised, and that's just that, and ask for you to clarify the source of income, which is not included in the state human rights law.
No, sorry, it is included in the state and the city. It is not part of the federal human rights law. And what it refers to is it has to be lawful source of income. So if you're, selling drugs, that's your source of income, that does not count. But if you receive, for example, government benefits or rental subsidies, those are, and someone discriminates, a landlord or a broker who's trying to consider your income for a mortgage says, no, we don't count those sources of income, then that is a form of discrimination. In the city, it only applies to homes of 6 or more families. So if someone is looking to rent a room in a private house and the landlord lives in that house and hasn't advertised it, I mean, it's there's a lot of minutia here, but the basic is that if it's 6 or less, it is probably that particular characteristic, and that one only, is probably not covered. If there are 6 or more units and it's rental housing, then it is very likely covered for source of income discrimination. Does that clarify?
Well, I think so, but we'll see what they say. They've also posted an AG website. I don't know if you guys want to take a look at that. If we want to share anything, we can send it through the larger chat box for everyone to see. So, but that's all the questions that we have.
Okay, great. So next we're going to talk about, and there are a few slides there about some technicalities, about some things that have come up about what's a dwelling, kind of similar to what Amy was just talking about. There are some technical pieces that you can take a look at that slide if you're thinking about whether your complaint might be one that you could bring, and of course you can always email us if you have any questions about those. We're going to talk about now investigating to craft your complaint. And some resources that you could use. So just like a complaint that you bring in court, of course you want to know your client's story really well, and then think about what can you do to bolster your client's story. What resources do you need to look at to bolster your client's story and help an investigator who's going to take this complaint and be running with it to really understand how what happened to your client is discrimination. So obviously you're talking to your client, you're talking to other witnesses, you're collecting their documents. You might do, further down the slide, qualified written request to get documents. You might talk to the time closer, try to get the origination files or get them from a get them from the servicer if it's a lending, if it relates to lending. And then you can, there's a lot of resources out there to think about who, what these wrongdoers might have done besides what happened to your client. So you can Google things, you can look at public records, look in the newspaper. ACRIS is a wealth of information. So whether it's housing or it's lending, and you're wondering, does your housing provider have other buildings? And how many buildings, or if there's a pattern, or how many loans has your lender made, or are there some other patterns? You can look at ACRIS. You could use Home Mortgage Disclosure Act data to try to figure out what's going on. What else is this bank doing? The network of advocates, such as the people on this call and people on the various listservs, are really great resources for others who have had similar experiences, court filings, bankruptcy filings, looking at bank examinations. As Amy mentioned earlier, there's opportunities to conduct tests where either your organization or outside your organization to send multiple individuals who would differ just based on that protected characteristic to see how they're treated. And that can definitely be a part of your complaint, that testers have the same experience as your client. And finally, maps are very powerful tools. They're it's very vivid, and it's hard to argue with that graphic. And so if there's something that you think is going on that's geographic, putting together a map is a really great thing to include in your complaint.
Yeah, they really, the visual really does pack a punch. I think Rachel covered this, but potential testimony, things you want to think about are, what could your client testify to? Are there other people who have experienced this or who can support the client's testimony? Written policies, advertising. Obviously the more documentation you have that reflects discrimination or at least implies discrimination is very helpful. Posted policies, even thinking about things like the notices that landlords put up in buildings that say, here are the rules, or in some buildings they put up these things that say, if you see something, say something. Are those kinds of, there's a building, in Queens that in a building that is heavily Muslim, they have posted a giant ICE poster that says, if you see something, say something, and then has all this information about how to report terrorism. That is not posted in their other buildings. So it starts to look a little bit strange and possibly discriminatory, and certainly if there are other things happening in that building, it can lend support to what's going on. Rent rolls, they're very hard to get, but if you can get the rent roll for the building, that's very useful. And again, I can't emphasize enough looking at what other litigation has been brought by the same entity, because if you can figure out who they've sued, this is particularly true for rental housing. If the landlord that you're looking at has just recently sued a large number of people in, say, holdovers with all the same characteristics, then that helps to suggest that they are targeting a particular group of people, especially if they have not brought similar levels of court cases against people with different characteristics. So that is.
And I see we have a question, which is a good question. What are bank examinations? I'm sorry to have said that without defining it. So banks are, by and large, examined on a regular basis by one or more of regulators who oversee them, and those examinations, which kind of can cover a variety of topics, but the things that are posted, the publicly available, tend to be a little bit dry, just about like, whether those banks are solvent, but sometimes have some details in them that can be really helpful about what neighborhoods they lend in, and over time, whether those neighborhoods have changed. And they sometimes are just economic information about the neighborhoods they lend in, but sometimes there's also information by race. And so it's definitely something, if you're thinking about a bank, to look at just to see if there's any facts in there that could be of help. And just the final cap on these slides is, I think that there is a lot of information out there, and it's all about how you're putting it together to be the most persuasive. And I always think there's probably another source out there I haven't thought of, and it's a good exercise just to think about what else could there be. What other kind of public filings might there be that I haven't looked at? Secretary of State information. Other, have this entity in state in any other way that I could foil it? Do a Freedom of Information law request. We're only limited by our imaginations. So just encourage everyone to think broadly. And then drafting your complaint. There's actually 2 samples that we included with the materials, and they're really different. So you can see that it's pretty broad in terms of how you want to put it together. Anything from literally a few paragraphs to something that looks more formal and more like what you would put together for a court filing. And again, you're thinking about the client's story. You've taken all that information that you learned from all your, delving into the various public records, that you're kind of distilling it down for the investigator in a way that's going to really catch them. And think about those maps, charting things to make it graphic and to make it persuasive. And finally, thinking about what parties you want to name in your complaint. You can do a separate complaint for each party that's participated in the wrongdoing. And so you can think about if you have, your one-stop shop with a lawyer and, a couple of different LLCs and an appraiser and, the person who went out and found your client and brought them in who might have been the same ethnicity as them. All those, you could name them all. And of course, just like when we're thinking about a complaint in court, it's good to think about who's your deep pocket and how are they involved, because those questions, your investigator is going to come to that right away, trying to understand how each of the individuals was involved, what their particular discriminatory activity is, and how you can support your complaint against each of them.
Yeah.
That's going to come up pretty fast.
And when you're naming individuals, it's also very helpful to think about how you're going to demonstrate that they're not acting on their own, because this is not about them being bad actors as individuals. It's about them acting on behalf of an entity that has a responsibility not to discriminate. So if you're talking about like a super, for example, or someone who is in a rental office, you need to think about making sure that you can demonstrate that they are acting on behalf of the landlord, the building owner, that they have some agency in that interaction. Detail is really helpful, as much detail as you can get. Sometimes it can be hard to pin clients down about dates and exact, interactions, but it is, the more detail you can provide, the more helpful. Finally, I just want to throw out there that you want to think, if you have multiple complainants, I think there are 2 ways to go about it. There's no reason that you can't bring a complaint on behalf of multiple complainants against multiple defendants. You want to think about whether that is the best way to pursue it. Often it will be, but if you think that there are going to be conflicts between the complainants, you may want to bring those separately, even though it might seem like you're writing exactly the same complaint over and over. You just have to think about that. I have had some experiences where I had wished I had done it differently in retrospect. And just a note on the attached complaint to the city, which is in there. That format should work for all of the different fora. but you definitely want to check the law. And even for the city, do not copy the law that's in there verbatim and the citations verbatim, because the code actually, there are some changes. And so just double check all that, make sure you're citing to the correct places, but that's to give you a general overall sense. So I just want to throw that out there in case anyone stretch your time. Okay. Oh, so now we're going to talk a little bit about the complaint process. It's pretty similar across all the agencies. We'll sort of focus on HUD as a primary example, but just know that most agencies, all of them actually go through something similar. So with HUD, you can file online, by mail, or by phone. The State Department of Division of Human Rights only accepts complaints via phone, in certain instances, and mail. So you can go online to download an application, but then you have to mail it in. Once the complaint is filed, someone from the agency will get in touch with you, or the complainant, and often they'll want to speak to the complainant directly, either by phone or in person. If you've done a very thorough job, this step may not happen. Or if they have all the information they think they need, they may skip this step. But even if you've put all of the information in the complaint, they still want to get a sense of who that person is. And so often they'll reach out to speak to the complainant. And then they will either take your version, what you've written, or they will draft a revised version, or they will draft a completely new version. And they'll send it to the complainant for the signature. And then they are supposed to send, and they do, in my experience, send a copy to the subject of the complaint within a specified time frame. The time frame is different for all of the different agencies. And then the defendant will have an opportunity to respond. They are also given a specified time frame within which to do that. That, in my experience, is never strictly enforced and always extended, which is one of the reasons why these can be time-consuming processes. So, as we mentioned before, HUD will refer the complaint to New York. They'll refer it to the State Division of Human Rights. And you should look at the text of each law so that you know what the time frames are. It can help move the process along if you know that, oh, in 20 days you're supposed to get some kind of answer from the defendant. You haven't gotten that. Now you want to follow up. It can be hard to reach people in some of the agencies, but you want to do that so that they're aware that you're paying attention, and that can cut down the time frame a little bit. So these are just slides that show you, like, this is where to go to file a complaint with HUD. This is if you want to file a complaint with the State Division of Human Rights. These are in no particular order except that this is how they appear on their own material. This is where you can take the forms in person. I suggest you just go to the website and poke around. You can also make phone calls. And if you have a visually impaired client, there's actually a specific contact for that. You can email them or call. And then the New York City, actually it should be the Human Rights Commission, you can just call 311. You can go to their website, and they tend to accept things online. Like, you'll get an email, someone will contact you via email, and then most of the following pleadings, rebuttals, etc., can just be filed online. You're supposed to mail a copy, which you should do, but the deadline, it'll count as of the time you hit send from the email.
So then thinking about what happens after that piece is complete, then you start interacting with your investigator and try to move your case forward. So I didn't put on the slide, but one thing that might happen up front is you might go back and forth a little bit with the investigator about how your case fits into the law. So if they're about statute of limitations, that might come up. Then you might end up writing, you know, a little bit of a briefing letter for your investigators so they understand the law on tolling, or how this has definitely come up in the context of lending, exactly where it is in the human rights law, so that they really understand where their authority is to investigate, and how the various entities are covered under the law. So you might end up doing a little bit of legal work up front so that the investigator understands the case. And you may have the opportunity to respond to the respondent's answer at that point with a rebuttal. And then it starts to feel a little bit loosey-goosey if you're coming from court, and that's what you're used to, because the investigator will kind of just send you a letter and say, I need this or I need that. It doesn't feel very formal at all. The investigator will say, well, they said this, and how are you going to respond to it? And so you're kind of thinking about, okay, you know a little bit more maybe than you might in court, because the investigator is telling you, okay, this is your gap. This is what I need, and how do you want to respond to it? So so you can think about, the documents you want to present, or even how, additional charts to show or additional maps to show what to make the investigator understand, because ultimately what you want to get here is you want a finding of probable cause. And you do have the opportunity to shape discovery. So even though in the state and the Human Rights Commission, it's very investigator-driven, and all of them it's really investigator-driven, but really in the state and the city it's solely investigator-driven, you can sort of encourage your investigator, this is what we need, and encourage them to get the things that they need. In the federal forum, there actually are ways that you yourself can seek information through the administrative forum by asking for it yourself. So it's not you join the investigator in participating in discovery. It doesn't have to be that way. You can let your investigator do it all, but it does give you an opportunity if you think there are things that are lacking but you're going to need at a hearing or need to get a good settlement, you do have the opportunity to get those yourself. And then you want to always want to be thinking about your damages and what documents you want to put forward to make sure that your damages are well documented, because when you get to conciliation, which happens pretty quick in this process, you want to make sure that the investigator or the settlement judge or whoever in the forum for they have different names, but you want to make sure that they understand how much your client has been affected. And so, as we discussed earlier, and have mentioned a couple of times, again, it can feel a little bit loosey-goosey at hearings as well, and conferences. In the federal forum, once you get to the hearing, their federal rules of evidence do apply, but that is not the case in the state and in the city. And so that can allow you to be a little creative. Also, you can put forward evidence that wouldn't pass muster in a court, but very much true, and does bolster your claim, and the ALJ, the law judge, will consider it. And so you have opportunities there.
Yeah. So if you have a case where there's a lot of evidence that's either hearsay or that might not pass muster in a court, this is a time when it might make sense to file an administrative complaint, because that evidence can and very likely will be considered. Now, this cuts both ways, because it also means that the defendant has the opportunity to present all kinds of hearsay evidence and evidence that doesn't necessarily have a foundation laid for it. So you do want to have some sense of what you think that they might have as well. But it does give an opportunity to be very creative.
And then there is an opportunity in each of the fora to have conciliation. The laws all contemplate that conciliation will happen, and that there's an opportunity to have a settlement conference, essentially. And as we discussed earlier, damages may may be lower in the administrative forum, but you can still do pretty well. And so, you know, sometime along the way, when evidence is, when the documents are coming out, you will have the opportunity to sit down and talk settlement. One thing which we did not, I did not mention under discovery, but want to just make sure everyone knows is, because it's investigator driven, sometimes you may not know what the investigator knows. You may not see everything that the investigator sees, which is one of the drawbacks, I would say, to the administrative forum. And things are not necessarily public. So even though you're getting documents, or you may be getting documents, you may not be able to do a press release about what you found. So that's something to think about.
Yeah. It also means that the investigator that's assigned to your case will, if you get a great investigator, they may run with something. If you get a less stellar or enthusiastic investigator, you may be pulling teeth to try to move things along and convince them that this is a viable case that really should move forward. Just a quick note, any agreements that come out of the mediation, conciliation, and settlement process are enforceable, and they're referred to other entities to do the enforcement, but they are enforceable. So what is it you're looking for with the complaint process? What you really want is you want the investigator and ultimately the commission or the division or HUD to find reasonable or probable cause. They refer to it, each forum refers to it slightly differently. And to do that, they need to be convinced that it is very likely that a violation has occurred. And then that's when this moves on to either an administrative law judge for a hearing, or at that point, if they find probable cause, you know, you may have used this primarily to get discovery and to get a sense of your case and to give you time to build it. So you may decide, okay, now I want to take this to court. If you do go before the administrative law judge, what will happen is a lawyer for whichever agency you're dealing with will present the case. You can be part of the case, but you will not necessarily be the lawyer for your client. And this is because when the agency brings the case, they are bringing it on behalf of the city or the state or the federal government, not necessarily just on behalf of your client. So there's just a little bit more information around here. The decisions of, once the ALJ makes the decision, there is an appeal process. Sometimes that appeal process is internal, and here's some information about the HUD's process in particular. But if you don't like the decision, or if the other party does not like the decision, that decision can be appealed outside the agency. So for HUD, it would go to the appropriate court of appeals. For the Division of Human Rights at the state level, you can appeal decisions to the state Supreme Court. There's a 60-day time frame. And that applies both to decisions after a hearing, but that also applies to decisions if the State Division of Human Rights decides that there's no probable cause. You can also appeal that decision to the state Supreme Court. With the Human Rights Commission, you can also go to the state Supreme Court. That deadline is shorter. It's 30 days. So just be careful that you pay attention to the time frames for appeal, because you don't want to miss those. If you have a decision you don't like and you want to appeal it, you want to make sure you get that appeal in within the proper time frame. One of the interesting things with the commission, very quickly, is that they can dismiss it for administrative convenience, and this captures a whole range of things, some of which are unclear, and that does not mean that they did not find probable cause. And you can bring the complaint again at a different time. It just means that they are not going to continue investigating at that moment. So this is just kind of reiterates what I just talked about. It is, I think, an important feature of all these processes is that if the landlord or the lender tries to retaliate against your client, that retaliation claim survives even if the agency finds that there's no probable or no reasonable cause that there was discrimination in the first place. So you can pursue that retaliation claim even if you lost at a hearing or if it was dismissed before a hearing for a finding of no probable cause. Should we switch? Okay, so we talked a little bit about this already, but an administrative judge can issue civil penalties which are payable to the agency or government. They do not go to your client. Actual damages, you can get actual damages. Those are payable to the complainant, and it includes, all of the things listed here. You can get injunctive relief. So if what you want is your client to move into an apartment or to be considered for a loan mod, in theory, the agency and the administrative law judge can issue that relief. I'll be quite frank, I have not seen injunctive relief issued at the state or the city level in any of the cases I have had. So I don't know the scope of what it would really necessarily look like and how much authority they think they have. Attorney's fees and costs, punitive damages are often not available.
So we've included our contact information. So, and we love to talk about these things. So please do call or email if you have any thoughts about it or any follow-up questions that don't get addressed today. And we sort of would bring it back to some of our introductory points that that discrimination is out there. Sometimes we're not thinking about it first, but this administrative process is relatively pain-free. It can be powerful, and it can also kind of make issues rise to the top that, a lot of folks, maybe our clients, maybe ourselves, maybe the administrative agencies are not thinking about as part of the problems that our clients are dealing with, and that can really help resolve other issues as well.
And as I think Jay had mentioned in the beginning, given the political climate going forward, it may be that the New York State and city processes, and possibly even the HUD process, because HUD could be a slow entity to change no matter what the new administration is like. It's possible that these might be better for some of these issues. That is something we'll all have to see over the next couple of years. So I think at this point we will take questions.
So at the moment we don't have any additional questions out there. We'll give folks a few minutes. This has been incredibly helpful, and I think it's eye-opening for folks who have not considered this avenue for our cases. So thank you both so much for your time and effort on this.
Welcome.
Thanks.
Jay, I know you're still out there. Do you have anything that you'd like to add in the meantime?
The only thing I would say is, and I don't know if this is true or not, but I would imagine just as New York City has a Human Rights Commission, other municipalities may also have equivalent agencies that may also be appropriate places to consider claims. I would imagine the bigger cities and some of the counties. So that's just, people should check their own localities for those outside of New York City.
I think the best bet might just be to start with your local. There are a couple of fair housing units across the state. Those are going to be your primary source of resources, I think, to get access to this information. Okay, well, let's see. I don't see any additional questions, so I think we'll call it a day. Thank you both so much.
Thank you.
Thanks.
Yeah, and I
Have a
would
good day,
just like
everybody.
to add my thanks. I want to say in particular, it takes particular effort to integrate when two people are presenting together. And I think Rachel and Amy did a great job doing the work to actually present this together. So thank you for all the work you put into this.
You're welcome.
Thanks. Having your office share was very helpful, actually.
All right, everybody, have a good day. Thank you.
Thank you.
I'm sorry, one more thing. So just make sure that folks see the CLE verification code is W523, and that is in the chat box on your dashboard on the right-hand side of your screen. And I think that that's it. Have a good day, everybody. Thank you.
Thank you.